Today, we're diving into a really compelling Supreme Court petition. It pits a 34-year intelligence veteran against the Pentagon and asks a pretty fundamental question. Can you be fired for failing a test that your own doctors say is medically harmful for you to even take? I mean, just think about that for a second. The whole case really comes down to this single question. You dedicate your entire professional life to serving your country, but then you're faced with a choice. Take a test that doctors have confirmed will cause you medical trauma or lose your job. What happens when a standard procedure directly conflicts with a person's health? That's exactly what we're going to unpack today. So to really get what's at stake here, we've got to start with the man at the heart of it all, John S. Morter. 34. Let that sink in for a moment. That's how many years John Morter served his country, working inside the Department of Defense and the intelligence community. We're talking about a career built entirely on trust and decades of dedicated service. And here's the thing. This consistency is so important to the story. For that entire 3.5-decade career, Morter held a top-secret clearance without a problem. His performance reviews were great. The issue that ultimately derailed his career had nothing to do with the quality of his work as an analyst. So where did it all go wrong? Well, the conflict started with a pretty routine, but let's be honest, highly controversial tool, the polygraph, the lie detector test. And over time, for Morter, this standard screening became the source of some very real medical distress. You can just see how this whole thing spiraled over the years. It kicked off back in 2011, when the polygraph exam started triggering severe anxiety. By 2013, it wasn't just a feeling, he had a formal diagnosis: polygraph-induced anxiety with PTSD symptoms. But the agency kept pushing for more tests, and eventually they reassigned him. After the lower court sided with the government, his absolute last resort was to take his case directly to the Supreme Court. So you've got multiple doctors putting their opinions in writing. How did his employer, the Defense Intelligence Agency, or DIA, react to all this? Well, this is where the core of the legal fight really begins. The agency's response, according to the petition, was just completely uncompromising. They apparently ignored the medical evidence from multiple doctors. They compelled him to take more tests, the very tests doctors were warning against. They denied his requests to just temporarily postpone the exam. And then finally, they reassigned him from the analyst job he'd held for so long. And the only reason they gave? His inability to successfully complete the polygraph. Now, this is where the story gets a whole lot more complicated, because the agency's actions seem to fly directly in the face of the Pentagon's own rules. There's a binding Department of Defense instruction that clearly says no negative action can be taken solely because of an unresolved polygraph. And Morter's whole argument is that that's exactly what happened to him. And this is a really crucial point. While the polygraph itself was flagged as unresolved, formal security reviews actually looked into the whole situation, and they came back clear. They found 0 security violations, 0 misconduct, and they recommended that his access just continue. His top-secret clearance was never actually suspended or revoked. So, when Morter sued, how did the courts handle it? Well, the lower courts sided with the government, and their entire decision hinged on the legal definition of one very specific phrase. And that phrase is essential job function. Now, under disability law, an employer has to provide what's called a reasonable accommodation to help an employee perform the essential functions of their job. The courts basically decided that passing a polygraph test was an essential function of being an intelligence analyst. But Morter says, whoa, hold on a second, that's a huge misreading of the law. His position is that his essential functions were the actual work: analyzing intelligence, writing reports, doing the job. The polygraph, he argues, wasn't the job itself. It was a qualification standard, kind of like a background check or a medical exam. It's a hurdle you have to clear to get or keep the job. And legally speaking, those two things are treated very, very differently. And that distinction right there is the whole ballgame. It is the absolute heart of his Supreme Court petition, which asks the justices to answer 4 really critical questions. First, can an agency just relabel a test as a core part of the job specifically to get around its legal duty to accommodate someone's disability? I mean, if the court says yes to that, it could create a massive loophole in federal disability law. Second, does an agency have to follow its own rules? It's a simple question, right? Can it write a regulation that's supposed to protect employees and then just ignore it? This one is all about basic government accountability. The third question gets into some really heavy territory. Can an agency use the words national security like a magic wand to make any judicial review of its personnel decisions just disappear? Especially when it never even formally revoked the person's security clearance in the first place? And finally, the fourth question is about the process. Disability law requires a good faith, interactive process, a real conversation about accommodations. So, can an agency just refuse to have that conversation, ignore the medical evidence, and get away with it? So, okay, one case, one person. Why should we care? Because the outcome of this could have ripple effects that go way beyond the walls of the Pentagon. The stakes here are just incredibly high. The Supreme Court's decision could literally redefine the rights of thousands of federal employees with disabilities. It could hand agencies a playbook for how to sidestep their legal duties, expand their power to operate without real oversight, and ultimately redraw the line between the rule of law and national security. And we can't forget the human cost in all of this. This quote from Morter's petition really brings it home. He says that after 34 years of service, the agency's actions didn't just end his career, they destroyed it and made his medical condition so much worse. So, in the end, we're left with this one critical, overarching question. This case isn't just about a polygraph test or a single analyst's career. It's about finding that balance. In a world full of secrets and threats, how do we protect the country while also protecting the fundamental rights of the people who've dedicated their lives to doing just that? The Supreme Court might just give us an answer.